Kia ora tātou. This is the 22nd day of our hearings on the submissions on Plan Change 7, and we welcome again Federated farmers, and we look forward to hearing from them. And Dr. Hume, you have already introduced us to Mr. Grant, but I don't think that we have met Mr. Henderson yet.
Well, Mr. Henderson is immediately to my left.
Yes.
He's joined us today partly because he's the North Canterbury President of Federated Farmers, and the plan is today we in part talk about the WRRP sub-regional plan.
Split. Thank you, and welcome, Mr. Henderson.
Thank you.
Now, we have received from you, three of you, a joint statement, and we've all had the opportunity to read that, but you want to speak to it, of course, and we welcome you doing that, and we may have one or two questions of you after you've done that. So just proceed when you're ready.
Yes, our plan is that Cameron will make an introductory statement, and then we'll just answer any questions you may have.
Thank you.
Thank you, Commissioners. Good morning, and thank you very much for this opportunity to present today. So as Lionel introduced me, my name is Cameron Henderson. I'm a dairy and arable farmer based up near Oxford. I'm farming in the subzone Area A. It's as described in Plan Change 7. I am the Federated Farmers President for North Canterbury and also a member of the Waimakariri Zone Committee, and since 2017 the current Vice Chair, but appear before you today firmly with the Federated Farmers hat on. So you've heard many stories from farmers, my neighbours, over the submission process, so I won't elaborate too much on my own story, but I guess suffice to say that like many of those farmers, have made decisions to build my farm and my business over the last 10 years based on what was the best information at the time. More recently, with new information available, I also, like my neighbours, increasingly feel trapped, not wanting to have any negative impact on the environment, but still wanting to provide for my family and the three families that work with me, but having fewer available options to achieve both. So that led me towards, considerable environmental investment on my property, to my role with Federated Farmers, and more recently, my role with the Zone Committee to try and find a way forward for our community. So having sat in a similar position to yourself as part of the Zone Committee process, hearing submissions, science and evidence, and the creation of the Waimakariri zipper, I can appreciate the difficult decisions that lie ahead for the three of you. I would like to speak briefly to one of those difficult decisions that didn't come across our table, and that is the impact on the MPS 2020 on Plan Change 7. So as Commissioners and other submitters have highlighted, the new MPS 2020 does provide strong directives on new targets for water quality. But I wanted to highlight that it also provides strong directives on how to deliver on those targets. For example, in Section 3.3 of the MPS, it directs formulation of a community vision in timeframes that are difficult but achievable. In Section 3.15, it directs the creation of an action plan that includes statutory and non-statutory actions. In Section 3.15, it also directs councils to undertake consultation on those plans with the community, with great emphasis on tangata whenua involvement, who also happen to be our largest single dairy farmer in the district. Finally, as stated in the Federated Farmers Summary presented today, the changes in regional plans to meet MPS 2020 must also be notified. These directives are important because they support a fair and democratic outcome where issues and options can be debated and a collective path forward set. I believe implementing broad changes to Plan Change 7 to meet MPS 2020 would go against these clear directives on path within the MPS 2020. On a personal note, I've also seen the benefits of following the MPS directives and bringing the community along with you in the change process. So what I would ask is that the Commissioners please place equal weighting on the MPS directives on path alongside the directives on the destination. In doing so, we believe it would not be appropriate to implement major changes within Plan Change 7 to meet the new MPS targets. That in the words of the MPS 2020 itself, it would be impracticable to do so. RMA deadlines mean changes to the LWRP to meet the MPS 2020 must be notified in 4 years. Plan Change 7 already sets a strong direction of travel for farmers over that time. What I would ask is that you give the collaborative process, the process that I've been involved in for the last 4 years, the next 4 years to follow the prescribed process in the MPS 2020, to develop a robust, effective and arguably more fair outcome for everybody. Thank you.
Well, thank you, Mr. Henderson. That's obviously been a matter you've been thinking through carefully, and we value that. Shall we go to questions now?
Yes.
Commissioner Van Voorthuizen, any questions?
No questions. I found the joint evidence statement very clearly set out what you're asking us to consider with reasons, so there's no matters that I wish to clarify with you. Thank you.
Commissioner Solomon?
Yes, I do have several, and I'm going back to your evidence lodged on November, 26th of November 2020, and I take you to paragraph 20. Where you talk about having regard to the Environment Canterbury temporary commissioners and improved water management. What matters do you think we are obliged to give more weight to? Those matters that we must have particular regard to, or matters that we need to recognise and provide for, or matters that we must give effect to?
Do you have examples of matters that are in those three categories?
Well, we have to have in 2017 NPSF, we had to recognise and provide for, but now with the 2020, we have to give effect to. That's the examples that I come to my mind straight off.
Well, giving effect to, I guess, is a more...
Whereas the CWMSF FM process, we have to have regard to.
I guess, if you're getting at what I think you're getting at, giving effect to is very explicit and directive, I guess. But as Cameron said, there is stuff in the NPS 2020 about both the destination and the path. And sure, we all have to give effect to certain things, but give effect to them in a certain way, using a certain process.
Well, that takes me actually to paragraph 27 of your evidence. We were advised by ECAN's counsel to give effect to the MPS FM 220 where there is scope to do so. So do you think that legal counsel would have considered part 4 of the NPS FM, as you've referred to in your paragraph 27, before he gave that advice to us?
Could you run that question past me again?
Well, I'm referring to your paragraph 27,
Yep.
where it talks about part 4.
Yeah, with regard to things that would partially give effect to the NPS FM 2020 and are within scope of the submissions on Plan Change 7, I think if people that submitted on Plan Change 7 had known the content of the NPS 2020 at the time they were submitting, they may have submitted rather differently to the proposed provisions in PC7 than what they actually did, not knowing about what's in the NPS 2020. So I would argue that well, there were certain things regional councils had to do straight away, which Environment Canterbury has already done or is in the process of doing, and they've notified publicly that they're doing that. But I think for the other matters, then the NPS itself says that we should go through a process of public notification and the processes that follow on from that.
Okay, I think I'll leave that there then. And I want to take you to paragraph 30 where you talk about, I think it's rule, policy 4.101, where you talk about original, there may be while it is often highly desirable from a biodiversity standpoint to safeguard original habitat, there may be situations where it is not the best option or where it is simply not possible. I couldn't find in the policy where it talked about original habitat. And then my question is, can you give an example of a situation that would require a better option?
Well, I'm not sure that...
Have you got your submission in front of you?
Yes, yeah.
Paragraph 30, and it's the second to last sentence.
Yep. Well, in terms of a simply not possible, if there's... I guess I was thinking in a slightly abstract way when I wrote that, but it could be, well, I guess you could conjure up all sorts of situations. It could be that the vital piece of public infrastructure needs to be fixed or adjusted, and perhaps there's no way of doing that without encroaching on some Indigenous habitat. So I think in pragmatic terms there always needs to be some option for mitigating that sort of action. But like we can concede in the paragraph, it's obviously, if we want to preserve habitat for Indigenous species, then the best way to do that is to leave it alone where it exists. But there are situations where that may not be possible or not desirable.
I mean, I've just got one more question about stock exclusion from waterways. And this is going to be a bit of a, if you just bear with me and I'll get to the point at the end.
Yeah, sure.
Have you read Mr. Lindsay Fong's evidence from New Zealand Deer Farmers Association?
No, I haven't.
Okay. At his paragraph 19, he references a report prepared for Environment Waikato titled Fecal Contamination of Rural Waikato Waterways. The report notes on page 5 a range of gastrointestinal diseases caused by farm animals and birds when they urinate and defecate in waterways. The diseases cause major health effects to people when they drink untreated water. The main diseases include campylobacteriosis, Giardia, Salmonella, E. coli and Cryptosporidiosis. The report goes on to say dairy cows are more likely to defecate while the herd is crossing a stream. In the Tasman district, research noted that dairy cows defecated 50 times more per metre of stream crossing than they did elsewhere. It appears that dairy cattle defecate at a higher rate when in water than when on land. However, beef cattle freely accessing water have been found to not defecate any more than they normally would on a paddock. So I think my point is that's why we would prefer to have stock out of waterways. And I just wanted to know whether you've got a view on that.
Well, I think there are already reasonably tight provisions that keep stock out of water, particularly dairy cows, in any intensively farmed situation, on the Canterbury Plains, for example.
So The waterways I'm particularly talking about is ones that are less than 1 metre wide.
I mean, if I can make the comments on that too. I mean, there's been a commitment from farmers, especially intensively farmed operations, to exclude stock from waterways. I know in my own personal situation, we've got a lot of waterways on one of our dairy farms, and I've spent probably $50,000 or $60,000 in the last 12 months, finishing off some of the waterways that aren't quite on the intensive part, but that are around the edges of the intensive part, and excluding stock from waterways. So there's definitely no issues around that. I think we have, in extensive areas, there are some issues of stock exclusion in steeper country, and where the stock are grazing more extensively. We've got some real concerns when you get up into the steeper country that the earthworks it's going to require to exclude stock from some of these waterways, and some of them are that metre and up to 2 metres. Those earthworks are going to create more environmental damage than what the positives of excluding the stock from these waterways. And in those extensive areas, stock just don't hang around the water and, as I said, defecate. So, yeah, there's definitely a commitment there from farming to exclude where we see the benefits to water. So I don't think there's too many issues there.
I base my questions around what I read in your submission, so that's why I've asked the questions.
Okay.
But I have no further questions, thank you.
Thanks.
I think that the experience of the last few years in the development of this planning process has led to a relationship between Federated farmers and Environment Canterbury that's really much more productive and constructive, and that's entirely to be commended. We've reached a stage, though, where we need to be focused on how long we're going to take to get to the ultimate objectives. The new NPS talks about as soon as practicable, or as soon as reasonably practicable, or some good words like that. And of course, there's room for a lot of differences of opinion about what's reasonably practicable. We had somebody in this room telling us it should be immediate, and we know that there are some people that you might be acquainted with who would think that putting it off for a generation would be a good idea. Do you think that we've got an opportunity here to be focused quite firmly on when we can expect there will be real achievement of keeping nitrate, nitrogen out of fresh water?
Commissioners, hopefully I can answer at least part of that question.
Thanks, Mr. Henderson.
I have been following the science of, while I proclaim I'm not an expert in hydrological issues, as a member of the Zone Committee, and then hearing and reading some of the evidence that's been presented to this submission process in the last couple of weeks, I've come to understand that hydrological flows in the Waimak district, and indeed all of the Canterbury Plains, follow a dramatically different timeline to that occurs in the majority of the rest of the country, where water flows are predominantly surface flow related, where rivers are recharged predominantly from surface flow, as opposed to the majority of the waterways, particularly in Waimak district, that are where the water is sourced from groundwater, and whose age is not measured in days but in decades and in some cases centuries. So I guess the challenge that I see, and particularly with the timelines around not only the previous MPS but the current MPS, is the conflict between the desire to reach an outcome as soon as possible, and I certainly share that desire, with the scientific possibility of what it is possible to deliver. That we can write plans and targets on a piece of paper and impose change on farmers, but arguably we are limited by what the natural world can deliver in terms of when those changes are made and then when those changes are seen in the waterways. So I guess by all means we need to investigate and understand the scientific and hydrological model within Canterbury to understand when changes are made, when we're likely to see the outputs from those changes. But part of that is also being realistic, and that if we're not seeing change in, for argument's sake, 5 or 10 years, such as the MPS dictates, that's not necessarily a fault of the planning process or the action plan, as the MPS talks about, that it could simply be the fact that science cannot possibly deliver an outcome short of sucking all of Canterbury's groundwater out, filtering it and putting it back in again over that time frame. So when it comes back to practicable outcomes, solutions and timeframes, and certainly expectations for all of those stakeholders involved, that we do need to consider what it is possible to achieve in certain timeframes, and that is where the debate around those expectations over the science, over the modelling, is extremely important. So I'll leave it there. Thank you.
Well, that's a very helpful response to my question, Mr. Henderson. I'm grateful to you for that. For all of that, there's certainly quite a sense that intensive dairy farming results in nitrate, nitrogen getting into the ground and into the fresh water. And that doesn't require quite such imaginative ideas as taking it all out and filtering it. It's just a matter of finding ways to stop doing it in the first place. And I know that many of your comrades, if I can use that term, have been remarkably energetic and ingenious in looking for ways to achieve that. And that's all very commendable. But does there come a time where, if we're going to avoid more nitrates getting into the water, that maybe there has to be some attention to what degree of intensity of dairy farming is tolerable by the environment?
Probably can I first say I certainly agree with I guess what is considered the known facts, that dairy farming does have an impact on the environment with regarding to leaching. What I'd probably also draw attention to is that in the Waimakariri district, and I'm not sure how common this is throughout the country, that in comparison to the MPS 2017, which is where the basis for the zipper and Plan Change 7 came from, and I understand that that has now been updated, that the water quality issues, particularly in lowland streams, were modelled future outcomes that if you compare the current state for a lot of those waterways with the bottom line, we have few lowland waterways that actually breach the MPS as it was at that time. That the situation we're facing and the changes we're enforcing on land managers is a result of modelled future outcomes, modelled solutions, and a modelled impact on the land. Now, I'm not debating that's the best science we have. That is, there is no way, I guess, to find a better solution at this time other than modelling, and that's the decisions. That was the science, but the decisions on the zipper were based on, and it is difficult, I guess, given the precautionary nature now of policy setting, to argue with that. I guess in the back of my mind, personally, when I was considering it, was that when looking at the precautionary approach, to certainly not do anything at all was irresponsible, would be irresponsible. And I'm sure that you share that view, that if there is a chance that there could be an impact, then we do need to make some action in the lack of better evidence. On the flip side of that, I guess, is always the question of what if the science is wrong? and what impacts could we enforce on people to later find out were not necessary or were too great or were in the wrong place. And that comes, I guess, with the level of uncertainty in the science and the modelling, and comes down to, I guess, the balancing of the cost of the data being correct versus the cost of the data being wrong. And I probably point to the expansion of dairying, and yes, I'm a dairy farmer myself, of the best knowledge at the time, 10 years ago when I bought my farm, was that really you could irrigate any piece of land in Canterbury, particularly up in my patch, and that was a good way to make the land more productive, to make the region more economic, and actually that was great for the regions. It provided employment, provided rates payments to the council. There wasn't a great understanding of the impact of that science in the future. Now, we are now trying to correct some of that lack of information or that poor science back then, and my hope in my part of this process and in every part of this process, I guess, throughout Canterbury and nationally, is that we don't set policy that pushes farmers in a direction or land management in a direction that is overly costly or to the environment or to the economics of that particular region, when in hindsight it was not the correct thing to do. So there again, coming back to that balance of what if the science is right versus what if the science is wrong, and the costs of each of those.
Well, that's a thoughtful answer, Mr. Henderson, and I'm grateful to you for it. But I acknowledge that you're saying, look, the science isn't perfect and it may prove to be not right on the mark. I also understand the point that the three of you have made in the paper you presented today about how much of the NPS 2020 needs to be processed in this Schedule 1 way, with consultation and public notification and so forth. But there are some things in the NPS 2020 that don't need to wait for that process. And in particular, I think I find myself advised by section 1.6 about best information and the absence of complete and scientifically robust data, and saying that people who are required to make decisions must not delay solely because of uncertainty. And because that's in my mind, it's fair for me to bring it to your attention as well, in case you can show me that that doesn't apply to what we've been talking about.
No, I would completely agree, sir, that the need to act based on the best information is certainly the principle that needs to prevail. It was also, in my view, the result that you see in the Waimakariri zipper is based on that principle that, like you, we have been presented with various views on the modelling that exists in this district, the inaccuracies, and particularly the interzone issue where groundwater is potentially flowing under the Waimakariri River into various areas of Christchurch, all based on modelling that has an element of uncertainty in it. But the zipper, and I believe Plan Change 7 as it is written, has acted on that regardless and is enacting change. For example, where I live in Zone A, looking at the detail of the map, is right at the heart of that country that appears to be feeding under the river into the Christchurch zone. I personally will be facing reductions of 30% on my property over the next 20 years, on top of a 15 to 20% reduction just to meet good management practice, so a total of over 50% reductions based on a model that has been developed in the last 2 years that, yeah, as I guess with a limited life, hasn't been given time to be robustly tested or ground truth. And I understand that the timelines were tight with ECAN on delivering that model, but it was the best information available at the time, and I'm going to have to make changes on my farm based on what's in PC7 to meet that best information. I have no argument about that. I guess it's just looking at the long term, that we know that this information is going to evolve over time, that this information, given the 80-year timeframes that Plan Change 7 set out, will change, and it's just that ability to adapt that action plan to the best information at the time. And that's, I guess, our argument as Federated Farmers, and for most of the farmers, that we are given that freedom to adapt rather than set an 80-year or 60-year plan at this point in time.
Well, thank you. As I said before, we, as hearing commissioners, we're very much aided when an industry body such as yours comes forward with a constructive spirit and engages with us in the way that you have. Thank you very much indeed for your assistance again today.
Thank you.
Thank you.
Good morning. Is this Miss King, is it?
No, sorry, I'm Eva Harris.
You're Eva Harris.
Hang on, was there someone else before me? Okay. Sorry, I'm Eva Harris. I'm the Environmental Manager for a group of irrigation schemes in Canterbury.
Thank you very much for coming in and your warm welcome.
So I just wanted to start to sort of clarify my position, because I understand you would see different submissions of evidence with my name on it. So the group of irrigation schemes that I work with, I have to read them out so I don't forget any, include Rangitata South Irrigation Limited, Barhill-Chertsey Irrigation Limited, Acton Farmers Irrigation Cooperative Limited, Greenstreet Irrigation Society, and I was asked for this process to support the Ashburton River Irrigators Association, which is a group of independent irrigators within the Ashburton district who have interest in the Ashburton River.
Explain.
So the schemes that we work with operate in both the PC5 area, in the PC2 area, and in the PC7 zone. So I have split my evidence to focus on the omnibus plan change provisions around the commercial vegetable growing, which is what I'll be asking questions for this particular session, and then later on with the Rangitata South specific around the OTOP zone rules that are coming in that will be related specifically to Rangitata South.
Well, thank you for that. Just help me to be clear about a little point of no great significance perhaps, but we had received some legal submissions on behalf of Rangitata South Irrigation. And you're speaking on behalf of Rangitata South Irrigation and some other irrigation schemes as well. And that we certainly had anticipated that, and we had received material from you. But are you aware of these legal submissions?
Yes.
That were lodged by Ms. King?
Yes. So she's just there. She was going to speak to the Rangitata South matters later on in today's session.
I see.
So at this particular point, I would like to focus on the commercial vegetable growing rules that were in the omnibus plan change that mostly relate to the other irrigation schemes, but there are commercial vegetable growers within the Rangitata South area, and it did form part of the submissions. But for that aspect of the Rangitata South submissions, we were wholly in support of the Hort NZ's evidence and submission process.
Well, I'm sure it'll become clearer as you progress, and certainly we want you to feel comfortable about presenting just as you would like. So just go ahead, and we have from you your evidence in chief. We have also a summary, and we have read those, and we, in fact, two statements of evidence in chief and a summary, and we would like you to present just whatever you would like and in whatever order that suits you. Try and keep us navigated so we know where we are.
Yep, so at this point I would like to focus on just the commercial vegetable growing rules. We did want to say that we were wholly in support of the evidence provided by Hort NZ as well as Potato NZ that I've since seen since we put in my original evidence. The key thing is I just had a couple of areas of relief that were slightly different to the angle that Hort NZ's approached, particularly in relation to how the commercial vegetable growers sort of provisions could be implemented through Schedule 7. I summarised that in my supplementary information I submitted last week in terms of what those key points of relief, and I just I assume, as you say, that they have been read, and I was just available to answer any questions that you had on those slightly different points of relief.
Well, that's splendid, thank you. Just a moment and get that up. So I've got the document in front of me. Is there a particular part of it that you'd like us to have in front of us at this point?
If we go to the table that are through the end of it, just in terms of the particular relief that I sought, which is, as I said, subtly different to what Hort NZ or Potato NZ have promoted. So under the Section 4 policies, we promote that the commercial vegetable growing rules are not limited by nutrient allocation zone. And I think you're aware of the evidence presented yesterday around the importance of the crop rotation, and that crop rotation, it's challenging to manage that within nutrient allocation zones adequately.
And with this material that you've just reminded us of in the table, how does that relate to what is requested in your client's original submissions?
So this is copied and pasted from the original submissions. So,
Splendid.
yep. So,
that's fine.
Yep.
Well, I think then you've brought me up to understanding where we're at. And now I'll invite my colleagues to ask any questions they have of you about that. Commissioner Van Voorthuizen?
Yeah, yesterday we heard from Horticulture New Zealand, and at the end of their presentation they agreed or informed us that they would be doing some further work on the recommendations they'd made to us, and they'd be sitting around the table with Potatoes New Zealand and ECAN staff to do that. Are you part of that process?
Yes, they have invited me to be part of that process. If I am not physically able to attend those types of meetings, I will be working with Hort NZ so that they're familiar with our proposed relief.
Oh, that's good, because the changes you're asking us to make in the table attached to your summary are quite radically different from what they're proposing. I mean, they recognise the problems with putting a vegetable growing operation through the farm portal, whereas your provisions request the farm portal to be used, for example. So if you could sit down with them, that would be great. And hopefully you can reach a common understanding on what you recommend.
Oh, yeah. And my understanding was that the farm portal was not within the scope of these submissions, so that's why I haven't made any comment on that.
No, but it's just your
Yeah.
track changes, amendments in your tables still refer to the use of the farm portal. So anyway, all right, but it's good that you're going to sit down with them and hopefully put your collective heads together. Thank you.
Commissioner Solomon?
No, I have no question, thank you.
Very well. Well, Ms Harris, as far as the commercial vegetable growing is concerned, is there anything further you have to say, or anybody else that's going to speak in relation to that?
No, I was just wanting to provide you with the opportunity to ask questions on what we were requesting.
Yes, well, as you see, we're in a state where there's progress being made.
Well, I guess I'll talk to you soon.
Now, we welcome to you. You're Ms King, are you?
Yes, sir.
Good to meet you, thank you. You're going to be counsel for all of these people, are you? The various irrigation schemes, including the Rangitata South?
Oh, sir, a point of clarification, no, just appearing for Rangitata South Irrigation Limited in this session, sir, particularly in respect of RSIL's relief regarding the proposed exemption to the nitrogen baseline, and also in support of managed aquifer recharge positions taken by other submitters. Still in support, sir, of the vegetable growing propositions made in that separate evidence presented by Ms Harris, but not necessarily presenting legal submissions on that aspect, sir.
Well, thank you. If we're just a bit slow in catching up about how this is being presented, never mind about that. We want your clients to understand that we are keen to understand well the case that they have to make on their submissions.
Thank you, sir, and I do invite you to just request a point of clarification if that becomes unclear during my presentation. Ngā mihi nui kia katoa, and I also thank you all for your time this morning as we near the end of these hearing days. If I could just start, sir, with some housekeeping matters. I have 3 to run through, if that is all right. You will have seen from my submissions that Ms Grant, one of our fact witnesses, is unavailable to attend today. She has an infant child at home. However, we do have the very next best thing, which is the farm advisor to her properties, Mr Mark Everest, who is separately presenting with us this morning in an expert capacity. He's comfortable to speak to her evidence and answer any questions from the panel. In addition, we also have the benefit of Jason Grant, who you've heard from this morning. He's a family member, and so if there's any gap in Mr Everest's knowledge, we may be able to have a quick sidebar and ask Mr Grant if he's able to assist any questions from the panel in respect of Ms Grant's evidence.
Yes, thank you. We had your message to say that Ms Grant is available in person this morning. So thank you for that.
The second matter, sir, and you may recall from the evidence filed, Ms Harris and Dr Treweek are married, and today they unfortunately do not have childcare arrangements made. So what we've come to is Dr Treweek is about 30 minutes away on standby, and once Ms Harris is presented, we will be able to call them in, and they will be able to swap parental duties, and Dr Treweek will present later on.
It'll be our pleasure to cooperate with that.
Thank you, sir. Appreciate that. And then the third matter is just the witness order this morning. Proposed to start with Ms Harris, then Mr Turley, then Mr Everest speaking to his evidence as well as any questions for Ms Grant's evidence, then Mr Ware, then Dr Treweek, and then Ms Rushton. Now, I anticipate it is possible, sir, that there may be an interlude required as we await Dr Treweek's arrival if we progress through those witnesses in between quite quickly, and I'd ask the panel to humour us in that respect. Thank you.
We'll be glad to do that.
Thank you, sir. Appreciate it. With the pre-circulation of legal submissions, sir, I acknowledge they've been taken as read. I do, however, make two corrections to that evidence, that submissions, please. The first being at paragraph 5. The commissioners will recognise there. Sorry, paragraph 5, and that is on page 1, sir.
Thank you.
You'll see there in the subparagraph relating to August 2012 and the notification of the Canterbury Land and Water Plan, the panel will probably recall that the original Land and Water Plan did not notify the nitrogen baseline in it, and it was the decision version released later in December 2013 which incorporated that nitrogen baseline definition. So if I could just make those corrections there, sir.
So just let us be clear about which words you want to omit and which words you wish to substitute, if any.
Certainly. In the line of August 2012, if you could strike from that sentence all the words following the LWRP, and instead insert beneath that an additional line reading December 2013, hyphen, the decision version of the LWRP includes the nitrogen baseline definition of 1 July 2009 to 30 June 2013.
Thank you.
And sir, there will be a very similar correction to Mr Turley's evidence, I understand, coming shortly.
Let's do one document at a time.
Of course.
We have submissions before us. If you have any other updates or corrections to make, please do those now.
Thank you, sir. Just the second correction on page 5 at footnote 20.
Yes.
I refer there to the decision in 2009 of the hearing commissioners to grant related consents and water permits to the scheme. I refer to paragraph 14. I'd also like to insert paragraph 72 there as well.
Very well.
Thank you, sir. That's the housekeeping out of the way. If I may just speak briefly to some of the highlights and the themes of my submissions, and then be available for questions.
Thank you.
The Rangitata South Irrigation Scheme and its command area and subsequent irrigation within that command area were consented and part of the consented environment in 2009. With the way that on-farm changes have occurred, that's being intensification as well as some expansion or some supplementary irrigation to existing activities, the way those changes have played out as against how the Land and Water Plan controls on land use and nitrogen leaching have come into play has resulted in a group of shareholders finding themselves in the gap. To use an analogy, they've hopped on the bus and then when the ticket taker comes, they've found they don't hold the same tickets as others, or in some instances we have properties that don't have any tickets at all. Ms Harris can speak to the land use changes on relative to each property and why there are 3 properties that are currently prohibited from applying for resource consent for farming land use, and then also how there are 12 properties being held to their pre-scheme water baseline use as opposed to their activities post-water. Ms Harris also can speak to the quality of information and quantity that RSIL holds in relation to those shareholders and their activities. Throughout my submission, sir, I've referred to the requested relief to provide an exemption for RSIL shareholders into the nitrogen baseline definition. The word exemption's been used to mirror what currently exists in the plan for dairy conversions, and that's a deliberate use, but I do want to clarify that the intention of the submission is more to treat this as a rectification or a correction to the existing plan to incorporate all of the shareholder properties into GMP for their post-scheme water use. The evidence and analysis of Dr. Trewick gives us confidence that the adjustment asked for to include these additional 15 shareholder properties is of a scale that is not harmful, or at least at the worst de minimis, and that the effect on the starting point from which PC7's journey of reductions begins does not change, and in fact we submit that actually the distance between the starting point and the end point is probably or possibly shorter, even if only slightly, than as ECAN has modelled. We acknowledge the sector does need to keep looking at improvements within its operations and also to better environmental outcomes. And that will be no different when the Regional Council comes to the exercise of fully implementing the MPSFM 2020. And the benefits of additional modelling and the data that will be available at that time will be able to show what gains we have made since and also better inform what else needs to be done. We're asking that all RSIL shareholders can be a part of that process, measured against their post-scheme operations, which they were contractually and financially committed to prior to the additional land and water plan controls coming into force. And then just a final point, sir, in terms of managed aquifer recharge, it is mentioned in my legal submissions, but we aren't preparing a legal argument on that today. The position in our case for Rangitata South Limited is more to present some evidence that provides a bit of a case study for the commissioners and submits in support of the position taken by other parties, in particular the Hekio Hines Water Enhancement Trust. And that evidence comes from Ms Harris and Mr Weir today, sir. That concludes the overall summary comments I wish to make, sir, and may I ask if there are any questions?
Just a moment, I think. Commissioner Van Voorthuizen?
No questions, but having read all the material, I certainly understand the issue that you're putting before us, which is that of the 35 shareholders who developed during the baseline period, 20 of them qualify for the exemption because they'd either started their dairy sheds or they had effluent discharge consents, and just as a matter of timing, the remaining 15 didn't. And so I certainly understand that issue that you're bringing before us. So thank you.
Thank you, sir. And an additional comment that Ms Harris will be able to expand on is that 10 of those 15 shareholders could not have applied under that exemption because they aren't new or converted dairy properties. They are intensified or expanded properties, so not already catered for under the plan. But thank you.
Yeah.
Commissioner Solomon?
No, I have no questions, thank you.
Ms King, there were one or two questions that arose in my mind when I was reading the original submission, I mean the RSIL submission, and I'm not sure whether it's convenient for you if we look into those now, or would it come later in the way you're planning to proceed?
Yes, sir, I have a copy in front of me if I can help with questions now.
you. On page 8, concerning policy 4.100B, does that make sense to you? Can you find that?
Yes, yes, sir.
Oh, good. Where it says use a portion of that water for MAR, that this be permitted. So does this relate to an application for a water permit, or perhaps for amendment to a water permit?
Sir, I may need to confer with Ms Harris, but I believe the intention was for existing water permits to enable a portion to be used for MAR. But in addition, as I think of it, it could be used in an application sense. But certainly the intention was more for existing water holders, water permit holders, for example, the Rangitata South scheme, to then use a portion of that water for MAR.
So would that be an application for an amendment to the existing water permit?
Sir, I believe as submitted, it was requested as a permitted activity, and I acknowledge we fell short of asking for a rule in that respect. But equally, to measure perhaps the implementation of MAR, for example, what point sources are used or how else it is managed, I may need to defer to Ms Harris and Mr Weir on that point. It may be more appropriate to do in a variation or an application sense. But certainly we haven't gone to that detail in the original submission, no, sir.
Well, if you're thinking of it as modifying in some way authority that's been granted by a water permit, would the consent authority have to consider all the relevant facts and considerations then applying and make a judgment on them whether to grant or refuse the application in respect of the MAR?
Sir, I believe the intention was to, in particular in the Rangitata South Schemes case, there is already a presumption or certainly effects of MAR in the operation of the scheme and contemplated by the original decision. But I do take the point that if there's going to be an increase in that activity beyond what was already consented, then yes, there would need to be an assessment against the relevant considerations before, for example, that variation is made.
Yes. You know, between 2009 and now, we've learnt some things. Consent authorities have learned some things, as well as planning authorities have learned some things. And whatever might have been the general contemplation in 2009, when you look at it in the context of 2021 or something like that, there may not be the same general acceptance. So you can't really assume that it would be granted, can you?
Sir, I do agree. I suppose my response was more angled at the effects of the proposed activity as against the effects of the existing activity, but I do take the point that there is some difference there and it would be beneficial to make an assessment before a grant is made.
Thank you. Now, I have another question about the original submission. I think it's page 14, where an amendment is proposed to policy 14.420 and to rule 14.519.
Sorry, is that the page of the top of page 14, sir?
I haven't got the page, just got a note.
If you could just repeat the rule, sir, I'll
Yes.
locate it.
We're talking about the rule amendment that's being sought to benefit people who hold shares in the RSI scheme. And it's Rule 14.5.19.
Yes, sir, I found that one.
Now, what came to my mind when I read that was the question, should a public instrument, such as an RMA regional plan, confer certain public entitlements on a selected class of the public, defined by whether or not they own certain shares in a certain private company?
Sir, I think that's the implementation we've asked for required a measure to identify who needs to be accounted for in the relief, and that was a submission point submitted in the alternative to the primary relief we seek, and that identifying them as being the shareholders was the way to identify those persons, more to recognise the journey that has resulted in them being in that gap of the plan is tied inherently to the status of their shareholding. The fact that they are shareholders started their own intensification journey to lead them to where they are today, and by means of no other way of clearly identifying who those parties are other than their shareholding, that's where we've landed to on that proposed drafting. I think I do take the point, sir, that it's perhaps a novel approach otherwise in the plan, but equally I would submit that it's not too much further than is already already provided in the exemption for dairy conversions, that being a specific class of farmers provided for in the plan.
Yes, well, it just seemed to be a matter maybe more of principle than of being difficult to apply in practice, but whether public instruments should be selective. The other aspect of this particular proposed amendment says of the property held shares in the RSI scheme. Can a property hold shares? Or does it mean a person who at a defined time owned a property in a particular class and also owned shares?
Yes, sir, I acknowledge that perhaps could be tightened up. The shareholdings are linked to, certainly in the water user agreements, to particular land areas, and you hold shares in relation to your hectares and therefore an application rate per hectare. So we are trying to capture that point in time where the property was subject to shares. That landowner may change, but it's the property that's held in the that's relative to the shares in the water supply agreement, water user agreement, sorry, sir, that is relevant here.
So I think that you're starting to see that there may be some scope for you to improve the drafting of this part of the request. Are you offering to do that?
Certainly, sir, we can take a look at that based on the questions today and look at that in conjunction with Ms. Rushton and come back to the panel with that.
Thank you. Now, there was one question that arose just complete your note.
Yes, sir.
I also have a question, if I may, about paragraph 29 of the legal submissions that you kindly presented.
Yes, sir.
Does this notion of dilution benefits from MAR. In diluting nitrates in water, does all the nitrate remain in the solution? And therefore is the effect only to lower the concentration?
That is my understanding, sir. But I may have to defer to Mr. Ware on that one.
Yes, all right. Well, that's my understanding too. So in effect, the contaminant is still there in the water.
Yes, sir, it doesn't change the amount going to groundwater.
And that's the focus of the RMA in section 14, is it? The contamination of water.
Oh, sorry, sir, yes.
Right. Well, thank you for that. I appreciate your assisting us with those questions. Would you like now to go to one of the witnesses? Is it Ms. Harris?
Yes, sir. That one might be.
Now, Ms. Harris, we have read your evidence statement. Is there anything further that you are going to say about it before we come to questions?
I just had one point of correction of my evidence. So it's on paragraph 35. I state in paragraph 35, I comment, therefore a 4-year rolling average is a good representation of the operational post-development farm system. I would like to retract the term rolling and just use 4-year average.
You've just got ahead of me a little bit. I'm sorry, I beg your pardon, Ms. Harris. But I'm just bringing it up on the screen. A paragraph again?
35.
35. I'm so sorry to have held you up. Please announce again what correction you'd like to make.
I refer to a 4-year rolling average in my evidence. I did not mean to include the term rolling. It should just read a 4-year average is a good representation of the operational post-development farm system. Yeah.
Any other corrections or updates?
No, that was the only one that I picked up. Yep.
And you're not intending to give any further summary of it. We can go straight to questions. Is that right?
Yes, I did assume that the evidence is read, so I would be just taking any questions. Yep.
Any questions, Ms. Harris, Mr. Van Broekhuizen?
I don't have any questions about the exemption issue, but I do want to ask you a question arising from your paragraph 22 of your first brief of evidence. So the one dated 17 July 2020, and that's on page 8.
Yes.
So you raised there the issue of the Rangitata Autumn HNCA, high nitrogen concentration area, and you say there it would bring some simplicity to the position that the shareholders find themselves in. And I note that in the original submission lodged on page 16 of the table, you seek, or the submission sought changes to the planning maps. So it seems to me there may be scope to simply expand the HNCA so that it covers all of the RSIL shareholding farms that are shown in your figure 2, and therefore provide the simplicity that you speak of.
I probably prefer that it was aligned to like some kind of geographical feature like a road, because at the moment the line of the HNCA splits properties,
Yes.
so which creates challenges for managing it. So it's it's when those lines, those arbitrary lines are occurring within properties and within paddocks, the management of trying to split the loads and calculate the reductions can become quite challenging.
Yes, certainly understand that, but in terms of the concept of expanding that zone, which may be within the scope of your submission to cover all of the RSIL properties, would there be an acceptance for that?
I would query the need to expand it without any evidence to improve water quality, particularly given the land use restrictions that would then become applied on those properties that are outside that zone.
All right, so I was probably misreading your evidence. I thought that in your paragraph 22 you were actually advocating that the simplicity that would generate would be a good thing for the shareholders, but I take it that's now not your position.
It's relative to the existing situation with the 3 nutrient allocation zones, which it's more simple than the current position, but there are still challenges as to where it is located.
Okay, so just to be crystal clear, in terms of pursuing the possible change to the planning map that may be within scope of the submission, that's not something you'd wish us to do?
Yeah, other than to consider aligning it with a more simple or obvious sort of like property boundary lines or a road or something.
But not to roll in any additional properties?
Preferably not.
All right, thank you, but no further questions.
Commissioner Solomon.
Yes, I just have one question. At your paragraph 46, you talk about MAR being another tool to improve water quality. Has the RSIL considered any other tools to improve water quality?
Well, we do promote improved on-farm management. We do accept that our farmers do need to improve their practices. It's looking at probably the timeframes when water quality outcomes are expected and comparing that against the timeframes that are required to implement the farm system changes when you are solely reliant on farm system change to achieve those water quality outcomes. In the meantime, something like MAR may mean that we can get the best of both worlds, where more time can be allowed for our farmers to implement those changes while also being able to achieve those water quality outcomes in a shorter time frame.
Yes, thank you. I realise that I just took it for granted that on-farm reductions were going to happen, and we've heard about MAR, but we haven't actually heard of any other tools. I don't know if there are any out there.
I think there's potential for stream augmentation, so targeted stream augmentation, and I guess I'm also being open-minded that there could be some technological advances that we are unaware of may have some benefit that could occur over the course of the term of this plan.
Yeah. Okay. Thank you. I have no further questions.
Paragraph 52, please, Ms. Harris. To reduce or cease the intake, increasing the volume of water available in the aquifers. What would be the effect of this on the ecosystems of the aquifers?
I would anticipate if groundwater takes were ceased in preference to scheme water, and that could be relative to the cost of the water, why someone might want to do that. But it would mean that there would be a greater volume of water left in the ground, which is the best that we can achieve, because that water that goes on top of the ground, goes through the land, can bring nutrients through with it in terms of recharge. So if we can leave the water in our ground, it's a good way of being able to keep the volumes up. That volume does reduce the toxicity of nitrates in the water. So you're right in terms of your earlier comment around that is the contaminant itself, which can be an issue, but the effects on the environment and the effects on human health are related directly to the concentration of that contaminant. So reducing the concentration through having a greater volume of water is also going to have some significant benefits to both ecological and to human health.
So would you assume then that having more water in the aquifers would be beneficial to the ecosystem?
I would generally assume that having more water can be beneficial. In this catchment we have to be careful because more water can also result in flooding effects in some areas. So we'll just need to, it's around trying to make sure that there is a balance there.
There really needs to be careful consideration of the effects, doesn't there?
Yes.
Well, thank you, Ms. Harris. I think that's all we have for you. And perhaps it's time for us to take the morning adjournment now. And Mr. Turley could come after that. So we'll take a quarter of an hour break. Good morning. This is Mr. Turley, is it?
Yes, it is. Good morning.
Well, thank you very much for coming, Mr. Turley, and thank you for preparing your statement of evidence. We have read it with interest. Are you going to speak to it now, or shall we go straight to questions?
Yes, sir. I've got two corrections, please. Under paragraph 16, at the last sentence of that, I've stated that the chair of RSIL for nearly a decade. Could you please change that to over a decade?
Thank you.
And then, similar to what Ms King said on page 10 of my evidence, under 11th August 2012, can that stay until the end of the word plan, and then shift the balance of that sentence to December 2013 as pertaining to the nitrogen base period of 1st of January 2009 to 31st of December 2013.
Mr. Turley, I think I've gone to the wrong page.
So page 10 of the appendix, yeah. Sorry. Page 11. Oh, okay. Apologies.
Yes. Yep. Now, I'm on the same page now. That's a good start.
Yeah.
Give me precise than that.
11th of August 2012.
Oh, yes.
Can we leave the notified piece to the end of change of word plan?
Yes.
And then the rest be shifted to December 2013 as regarding the nitrogen baseline period.
Okay, yes. that comes into a later item.
A later date, yes.
All right, yes, understood, Mr. Turley, yes, thank you.
The scheme was the culmination of a lot of effort by many in the area after years of battling with dry conditions and poor yielding groundwater. Farmers were looking to make their systems more resilient and to make something of their land for their families, farming and the families after them. There's a great amount of work put into the scheme's development and build, not only by the scheme builder company, but by the chairman, the board members and all farmer shareholders. This work was all in front of us when the scheme was consented in January 2019, and this future was secured further when we all signed up water user agreements in 2010. We had some slowdowns with the intervention of the Water Conservation Order during the consenting process, and also some construction delays later on. We all shared some frustration when water was only able to be provided to some of the shareholders in the first season of 2013/14. Then there was a significant amount of time and effort put into getting RSIL into a position that we could purchase the scheme from the scheme builder, a process that took years and was not easy. It is difficult to hear that some shareholder farmers are not able to be measured against their post-scheme water use due to how the timing of the delivery of the scheme's water and the nutrient and the nitrogen baseline period have played out with one another. While we agree that farmers need to continue to look at how they can better their practices and improve environmental outcomes, we do not want to see these shareholders to be pushed off the boat now because they can't quite fit the nitrogen baseline years. All RSIL shareholders are essentially wedded to the expanded or converted use when they signed their water user agreements in 2010, not to mention the financial commitments they made before signing these contracts. Overall, we have a desire to see improvements as soon as possible within the parameters of what we're trying to solve here. But I think we've got to give time for science to work and deliver practical outcomes. And I think we don't know what we don't know, and I guess probably I give two simple examples of what's happened in our own cropping operation. A decade ago, we were applying 220 kilograms of N to grow a crop of ryegrass. A decade on, we're doing 150 kilograms and growing every bit or better yielding crops. And onions are the similar, gone from 200 kilograms to 120 kilograms to grow a field of onions. And if you'd asked us a decade ago to grow onions with 120 kilograms, our immediate answer would, it can't be done. But it's great what science can take us forward with. And yeah, so I'm happy to answer any questions, sir.
Well, thank you very much for that introduction, Mr. Turley. That's very interesting. Any questions for Mr. Turley, Commissioner Van Voorthuizen?
No questions on the timing of how the process unravelled for you, which you set out in your evidence, or on the exemption that you're now requesting. I just want to come back to that issue I was raising with Ms. Harris about the high nitrogen concentration area and how it doesn't straddle or include all of the shareholder farmers, and understand the issue she raised about the scheme, the boundary of that zone splitting paddocks or farms, and how that's not very helpful. We've heard a lot of evidence from farmers in the Waimakariri area which has different nitrogen priority area N-loss reduction requirements. So they're not all the same. There's 5 different types of reductions required. Some of them much harsher than others, and we've heard that sort of creates a divide and rule, or it goes against all of the farmers cooperating on a scheme-wide basis to achieving environmental outcomes, sort of pits farmer against farmer. Have similar issues arisen with your shareholders, where some of them are captured by that high nitrogen concentration area and are faced with reductions? And please don't look at whatever your lawyer's writing down in front of you. Is there dissension amongst your farmers that some are captured by the high nitrogen concentration area and some aren't?
I think a lot of lawyers' writing's pretty similar to that of a doctor's, and I struggle to read my own without trying to read somebody else's. But no, I think we're all united, and that's the great thing about this shareholder group. There's 20 farming families, and yeah, we're all striving for the common goal, and it's just, you know, and I think testimony to that is how we're able to pull together and buy the scheme. And it's, yeah, we all have to make reductions, and some are greater in some areas than others, and it's just the way, the lie of the land. And we've got other properties outside the Rangitata South catchment, and we've got varying rates on some parts of our farm and other parts of our farm. And but you know, it's just striving for those maximum reductions that we can physically achieve.
Yeah. Okay. So basically the message is no, the shareholding farmers, they accept that different requirements are imposed on some of their members than others, but that's how it is down there, and they're happy with that?
Yes.
Okay. Right, but no further questions, thank you.
Commissioner Solomon.
No, I have no questions, thank you.
Could I take you to paragraph 30 of your evidence statement, Mr. Turley, please? This is where you were telling us about the presentation in 2010. Now, by that time, by April 2010, public hearings of submissions on the proposed National Policy Statement, FM, had been completed. And a revised policy statement had been reported to the government. Is that within your knowledge?
Probably not that well up on all the details of it, sir, but it's my understanding, yes.
Yes. So when you had this meeting of the farmers who were considering the irrigation scheme, was the meeting advised that the national policy would likely require regional councils to manage land use to phase out contamination of streams and rivers?
No, it never come up in those discussions regarding the building of the scheme.
So you only got half the picture, didn't you?
I guess we're probably pretty excited about getting water and being able to feed our stock and grow our crops, really. Yeah.
Yes, well, I understand that. Well, thank you, Mr. Turley. Appreciate your coming in and giving us your evidence.
Thank you, sir.
So next it's Mr. Everest, is it, Ms. King?
Yes, sir.
Thank you. Good morning, Mr. Everest. Thank you for coming. I'll just, if you give me a moment, I'll bring up your evidence statement on the screen, but we have read it. Are there any updates or corrections to make to that statement, Mr. Everest?
There is one correction, please. Paragraph 28, page 6. On the second line, 219 hectares should read 228 hectares, and 228 hectares should read 219 hectares.
Oh,
Switch those two numbers, please.
Yes, thank you. Good. Any other corrections or updates?
That is all.
Thank you. So if you're ready, we'll see if there's any questions about it. Commissioner Van Voorthuizen?
No questions, thank you.
Commissioner Solomon?
No, no questions from me either, thank you.
Can we go to paragraph 11, please? Mr. Everest. When you were working with those farmers that you refer to in paragraph 11, were the farmers doing responsible due diligence about the proposal?
I would say yes. A large number of them had been working on investing in irrigation for a period of time before I started working with them. Many of them back into 2008, as I understand it, so they were conceptualising what they might be doing, visualising how their farms might change, toiling with decades of development on their own properties and what that might look like, and then undergoing psychological change of understanding and feeling what a massive amount of debt might look like, and learning how to run an entirely different farm program. But through that process, they look at most things. They look primarily at what the farm could look like physically, then go through the stages of understanding how much of their existing farm operation they can incorporate into the irrigated farm operation, preserve their knowledge, their history in the area, focusing on the finance at the same point in that, and of course thinking about the environmental implications of what that might look like. Now, of course, back in the earlier stages, the concept of drainage to groundwater was reasonably foreign to most farmers. It was something that was thrust upon rather than were acutely aware of at the forefront. Most of them were primarily concerned with excluding stock from waterways and preserving wetlands in the area. That was the main focus, and that was the main thoughts around environmental enhancements. It was only later in the piece, as we pushed through 2010, 2013, through presentation of LWRP, that farmers became much more aware of the potential impacts of what was being sought at a both national and regional level. But by that point in time, a lot of farmers had already committed themselves psychologically and financially to the scheme.
Well, thank you for that information. I just find it a bit hard to understand that they could have been unaware of all the public process that was going on in 2009 and 2010 about the new national policy on freshwater management.
They're aware of, I would say...
About that?
Sorry, repeat?
Would you have been advising them about that?
Yes, we were, but again, only acutely aware of it. So aware that it was coming, but not really aware of what it meant. I was reasonably heavily involved in other parts of work in other regions, so I was quite aware of the potential implications of what was likely to be coming up. But also at that point in time, we had an expectation that the issue of what we thought was a water use consent or water use agreement was effectively a a concession to operate an more intensive than dryland farm program at the time. The expectation was that that would all be encompassed so long as we all operated at a fair and reasonable management level without running around trying to actively pollute our waterways. We did engage regional council in terms of trying to ascertain what that would mean for RSIL at the time. I did for Ross and Susan, Megan Grant's property, and it was a very challenging process to get regional council to even tell us what we could or could not do and how we might be able to operate or what consents would be required to be able to operate. It was only finally in I think 2013 that we were finally granted consents in on certain properties to actually operate. So yes, there was probably plenty of information around, but it was all voluntary information, and in a lot of ways it was information that we weren't familiar with and didn't necessarily want to hear at that point in time.
Well, that's a very fair answer.
The truth is
I
the
can
truth.
understand that. Can I ask you now to come to paragraphs 19 and 20? You can see in your second sentence of 19, should be consented under a purpose drafted lawful exceedance rule. And then there's something of the same kind at the end of 20 about exemptions.
Hang on, bear with me for a
So,
second.
yes, just take your time to orient where I'm looking at.
Yes, with you?
Yes, good, thank you. So these are the views of some farmers, aren't they?
Yes, and those of mine.
They're your views too, yes. So you're representing the wishes of your clients, really?
And Rangitata South, yes.
Yes. So your viewpoint is advocacy. You're pressing on us their wish rather than being an objective piece of expert evidence. Is that fair?
Yes, that would be fair.
Yes. All right, I haven't misunderstood. Thanks, Mr. Everest. Thank you very much for coming in and giving your evidence and answering our questions. Ms. King, is it Mr. Weir you'd like us to meet next?
Yes, sir. If the panel is satisfied they have no questions relating to Ms Grant's evidence for Mr Everest, and otherwise we can move to Mr Weir.
I'm sorry, am I jumping ahead of your plan in some way? I'm sorry if I am.
Oh no, we can revisit with Mr Everest later if the panel has questions relating to Ms Grant's evidence.
Oh, I don't know.
But otherwise Mr Weir is seated to my left now. We could continue and come back to Mr Everest.
Commissioners, does either of you wish to ask any questions of Mr Everest about Ms Grant's evidence?
No, I don't, sir.
Neither do I.
All right, thank you. Well, let us then go to Mr Weir's evidence. Good morning, Mr. Weir. Thank you for your statement of evidence.
Morning, sir.
Are there any corrections or updates that you wish to bring our attention to?
Yes, good morning, sir and commissioners. Thank you for that. There's two very minor changes I'd like to make. The first is in paragraph 19 on page 6.
Yes.
The very last sentence, there's a part of the sentence reads, then any benefit for MA. That should read, any benefit from MA.
Well, thank you.
Thank you. And one small typo in paragraph 28 on page 9. The last sentence there begins with the word "an." There should be a clear reverse response. Makes no difference to the meaning of the paragraph.
Thank you very much.
Thank you.
Appreciate your care you're taking. Shall we go to questions then? Commissioner Van Voorthuizen?
Just a couple of questions, but firstly, just thanks for your evidence, found it helpful, and what I take from it is that the benefits of MA can be quite site-specific.
That's right.
Yeah. Just a couple of questions arising from para 25. In terms of MA and the aspirations of this submitter, where would the MA water be sourced from? Has that been discussed?
I believe Council might be able to answer that better, but I believe from the existing take within the scheme itself. And
Okay.
Yes, sir, and as it discharges through the races.
Okay. So it'd be from those huge storage ponds
Yes, sir, originating
from the
storage ponds
Rangitata River.
and then fed through the races.
Yeah.
Yes.
And your analysis assumed that the MA water contains no nitrates. Is that realistic?
the Rangitata water was very low in nitrates, so I guess no nitrates is probably not quite right. It's just very, very small. I don't have numbers in the order of 0.1 or
Okay.
grams per cubic metre, maybe even less in times. So in terms of the existing concentration in groundwater, it's relatively close to none.
Yep, and as low as 0.1 milligrams per litre.
It could be that sort of order, yes.
Yeah,
So I
okay.
don't have the exact numbers of measurement.
No, that was all right, just to get a, excuse me, a ballpark figure for that. All right, no further questions, thank you.
Thank you.
Commissioner Solomon?
Yes, I just have one question. I actually found your explanation of MA really helpful and clear and objective, so thank you for that, except I didn't find one part clear. And it's about two different waters, and like the receiving water and the introduced water, and why they don't mix evenly. Can you just give me a quick layman's summary of why that might be?
Yes. So the introduced water would be discharged into the groundwater system through the land surface, through soak pits, or for example, and that'll flow vertically through the unsaturated zone into the very first groundwater system, the very first aquifer. And that enters that system from the top of that water-bearing layer. And over time, further down, that would mix within that first layer. But when it first enters, it just enters through the top of the groundwater system, through the top of the saturated gravels, and takes time for it to mix.
So does that depend on the thickness of the top layer of the groundwater?
Yes, so the thicker that layer is, then the longer and further down gradient that'll take to mix fully, yes.
Okay, I think I've got it. Thank you.
Yep.
I have no more questions.
Thanks.
So do you agree that the MAR dilutes the nitrates in the groundwater?
Yes, yes I do.
And in diluting it, it lowers the concentration, but does not eliminate the nitrate. It's still present.
That's
Is
correct.
that right?
That's right, yes.
And we use the concentration as a measure of thinking about it. But the nitrate's there whether it's dilute or not dilute.
That's correct, yes. Perhaps I could, in terms of, I guess there's some objectives that are concentration based, such as the drinking water standards, and perhaps there are other objectives that are the mass based, which is just the total volume of nitrates. But in terms of the concentration, yes, it would anticipate that it reduced the concentration.
And just to help me to understand, can you give me an example of what they would measure by the mass of nitrates rather than the concentration?
So in terms of a receiving environment, a body of water, for example, is that what you have in mind, or?
No, I don't have mind. I'm learning.
Sure. Well, they measure the mass usually by measuring the concentration first, and then multiplying that by the flow over a certain time. And that might be important, say, for a lake, where there's a given volume of water in the lake, and you can calculate and estimate the total volume of nitrates in the lake that might then be available for growing plants or causing problems. So that's where the mass might come in helpful.
That's helpful to me, Mr. Weir, and thank you very much for that explanation. We're grateful that you've come in and the trouble you took in preparing your evidence statement.
You're very welcome.
Indeed.
Thank you, sir. Thank you, Commissioners.
Sir, it would appear that Dr. Troik has not yet made it on site. Perhaps Ms. Rushton could come and begin her presentation, unless the ordering is, you'd like to keep it as proposed?
No, whatever suits you. Ms.
Sure.
I think you'll be very happy. Just give us a moment to bring it up, please, Ms. Rushton. Welcome again, Ms. Rushton. Thank you very much. And of course, again, we're grateful to you for preparing your evidence statement. Are there any corrections or updates that you'd like to bring to our attention?
Thank you. Yes, there's just a couple. One is the same as you've previously been advised. My introduction refers to me as being a director of Inspire, and I'm no longer a director of Inspire, as I've previously advised the hearing panel. The other is more specific to some typos that are worthy of fixing because they're referring to the wrong policy numbers. So on in paragraph 45,
Thank you.
about halfway down that paragraph, I refer to, I'll start the sentence. The sentence starts, "It is possible that the section 42A report is referring to the sentence between policies 4.6 and 4.37. 4.6 is an error. That should say 4.36.
Thank you.
Further down that paragraph, there's a sentence that starts, "However, this sentence has no influence over the requirements of policies 1447 to 14420C. The error is in the reference to 1447. That should be 14417.
Thank you.
Thank you for that. They're the only corrections I have to make. I do have a couple of points of clarification. At the time I prepared my evidence in chief, Mr. Trewick's evidence wasn't available to me. I have since read his evidence and am satisfied that it doesn't change my conclusions at all. If anything, it probably goes some way to reinforce them, insofar as he's saying that if the exemption is put in place because of some of the modelling and numbers that were done, it doesn't actually change the starting point to where the nitrogen loss reductions need to be made from. So, excuse me, he will be able to explain that point further to you, and his evidence explains that, but just acknowledging that I have now read that evidence and am satisfied that it doesn't alter my conclusions at all. My second point of clarification, just to be sure, it may not have been completely clear in my evidence when I was talking about inserting changes to the definition of the nitrogen baseline. While I don't think it matters whether it goes into section 14 or is dealt with in the body of the definitions in section 2.9, my preference is that it goes into section 14 because it is a change that is specific to this OTOP area. It sits in my mind better within that part of the plan rather than changing 2.9. So just clarifying that. I have also obviously listened to some of the earlier questions around specifically identifying parties in a policy and referring to shareholders versus property and so on. In preparing my evidence, I see the need for the exemption and have tried to draft something that is as explicit as possible to the properties that would be disadvantaged if the exemption wasn't there. That trying to get it as explicit as possible is in my mind very important, so that there's not room for other parties to come in and take advantage of that exemption. So that's the intent of trying to be as explicit as referring to the Rangitata South and their shareholders. I appreciate the question around whether or how appropriate it is to reference parts of the community specifically like that. I am aware of other parts in the Canterbury Land and Water Regional Plan currently that do refer to specific bodies, like, for example, existing policy 14.4.2 does specifically refer to Rangitata South Irrigation Limited. And I think there's another policy in that general area of the plan that also refers to them explicitly. I appreciate that that's referring to a company rather than individual landowners, but I think it's been done for the same intent of trying to get that explicit nature about the matter that's being addressed by the policy. I think there is still room to relook at the words that are there to try and address some of the concerns that have been raised, and will endeavour to do that and provide some advice back through the hearing administrator. Along those lines, there is a particular change that I think is worthy of noting today that I will put in that advice through the administrator. Is I think that the planning solution that I've provided, the editing to the definition of the nitrogen baseline that I've provided in my evidence in chief, would be improved if we specifically referred to a period within which those operations should be assessed. So effectively identifying a new period in time that forms the baseline for these particular property owners. So that baseline that I'm proposing would be the 1st of January 20 2015 to the 31st of December 2019, recognising that that's the period within which the landowners would have substantively made the changes that they had understood that they were able to do. I think there's an advantage by putting explicit dates in there because it again makes it clearer, but also helps when the GMP nitrogen loss is then referred to, because it refers back to a baseline period. So by putting a period in there, it assists the flow on within the plan. Yeah. But I will provide that drafting along with some solutions to your earlier queries if that assists.
Of course it assists, and we're grateful to you. And would you do that in conjunction with Ms. King?
Yes, that's fine.
That would be what seems to be a helpful way of doing it, and then we understand it as being RSIL complete speaking.
That's fine, no problem. My final point of clarification is addresses the issue of the 2020 National Policy Statement for Freshwater Management coming into force after my evidence in chief was submitted, and I just acknowledge that I have looked through that document, considered my evidence in chief, and asked myself whether it would change my conclusions at all, and it doesn't. I see my recommendation there as being not inconsistent with the NPSFM 2020.
Well, thank you for giving it into that. Any questions, Commissioner Van Voorthuizen?
Yes, just cutting straight to the suggested amendment at your paragraph 50. Suggested amendment to the plan. I don't think section 14 currently contains a definition of nitrogen baseline, does it?
No, so yeah, apologies.
So this would have to be a plan-wide, in the plan-wide part of the plan, wouldn't it? In the region-wide part of the plan, if we were to...
I can see, in my mind, whether it sits within section 14 or sits within 2.9, it has the same benefit.
Yes. So just a follow-up question was going to be, given that we don't have a definition in section 14 currently of the nitrogen baseline,
yes.
If we were minded to be sympathetic to the request to provide an exemption, I was just wondering whether it might be more appropriate, and as you've hinted, I think you're thinking the same, to have a more bespoke provision actually in section 14 itself. And so rather than inserting a definition that's not currently there, I was just wondering if you'd given any thought to perhaps having a note under, say, for instance, policy 14.4.18 that would have the same effect of the change to the definition of nitrogen baseline that you're asking us to consider, and capture some of the issues that have been raised during the presentations this morning. I mean, the plan does have a number of notes that indicate when certain rules do or do not apply, and which rules override other rules. Yeah. So the plan is full of such notes already. So my thinking was that if we were minded to grant this relief, that it might be achieved in that manner rather than inserting a definition that's not currently in the plan. So maybe if you could factor that into your thinking, given you're going to do some further thinking about the wording.
Certainly, yep, I can put my mind to that and include that in my advice back to the committee. Yep.
And in terms of that note, I certainly take on board the point regarding the need for such a note to address the issue of a shareholder versus a property, or some combination thereof. So given it's the property that leaches, but it's the shareholder who would possibly hold the shares, well, does hold the shares in the irrigation scheme. So just working around those issues as well.
Certainly, yeah.
But other than that, no further questions. Thank you.
Commissioner Solomon?
No, I have no questions for Ms Rushton, thank you.
Just something about paragraph 37 I'd like to ask, please, Ms Rushton. The This is the question about the consents. Perhaps you heard some discussion about that before. Do you think that when the consent was granted for the scheme, the regional council was precluding itself from giving effect to policies in the superior instruments about restricting changes in land use to ensure that the quality of the fresh water is not degraded?
No, I don't think they would have explicitly excluded their ability to think about that.
And anybody who thought that they could rely on those consents to, as it were, keep them immune from action under the superior instruments, really wouldn't be entitled to have that confidence, would they?
I agree with you, I don't think they would. My understanding, based on the evidence that I've read of the various experts presenting for Rangitata South Irrigation Limited, is that there was a degree of reliance on the fact that they would be able to continue farming with the water through the consent provided for the taking and use of the water. And I think that my understanding is that their shareholders understand that they need to continue to improve and reduce the discharge from their properties. This concern about the exemption stems from the starting point for those farms from which they then have to be reducing their nitrogen losses. So the exemption that is being talked about is not saying you can go back to what you thought you could do when you got your water consent and just carry on. It's saying they need the opportunity to start at a helpful starting point from which then they can meet the nitrogen reductions that are required elsewhere in the plan. So I don't think there was an intent that they would be treated differently by having the consent. It's about the starting point from which the nitrogen reductions are then to be made from, which is consistent with the dairy farm exemption in B. It's the change in the starting point. Yeah.
All right, well, perhaps I misunderstood that sentence about the investors having confidence.
I think it was, just to be helpful, I'll just find the sentence which you're referring to directly.
It's at the top of page 12. The first full sentence on that page, starting as the necessary consents. Yes,
I think that's fine. Having just read that, I still think my answer that I just gave is consistent.
Yes.
So there was an expectation of being able to rely on being able to use the water and to farm the land, but that wasn't setting up an expectation that they wouldn't also have to be managing their nitrogen losses. Yeah.
Right. Well, thank you for that clarification, Ms. Ruston, and thank you for your fully prepared evidence statement. I'm glad to see you again.
Thank you.
Sir, Dr. Trui has arrived and we're able to move on to his presentation.
It's well managed, thank you.
Seamless.
Yes. it's seamless for the offspring as well. Now, Dr. Trewick, we have read your evidence statement and we're grateful for it. Are there any corrections or updates that you'd like to bring to our attention?
There's one minor correction. Paragraph 37 of my evidence. I'd like it to read, it is therefore not clear leakage losses have been included in the assessment used to establish the on-farm reductions.
Thank you.
Yeah,
we should have a note of that.
That is all, thank you. Corrections.
So, we may go now to questions. Commissioner Vanville?
No questions, thank you.
Commissioner Solomon?
No, I have no questions either, thank you.
And I have no questions of Dr. Trewick either, so you've come, and I hope you don't feel in vain, but at least you've had the opportunity to clarify paragraph 37.
Okay, thank you.
We're grateful to you for your contribution.
Thank you.
Ms. King, where are we at now?
Thank you, sir. If I may just touch on two aspects, one that's come up during the presentation and one that has come to my attention afterwards. Firstly, picking up on Commissioner Van Voorthuysen's questions of Ms Harris relating to the submission point about potentially altering the extent of the HNCA footprint. I just wanted to clarify, and I did speak with Ms Harris before she left. The intent of the submission point was to potentially shrink the extent of the HNCA, and I understand other submitters, for example, Dairy Holdings Limited, have requested perhaps it be looked at in terms of following a red-orange footprint rather than encompassing the green areas as well. That was the intention of the submission point at that time, but Ms Harris's comments in answer to that question do still stand. And secondly, sir, I referred in my summary to information that Ms Harris was able to speak to and was not quite covered. And I just wondered if the commissioners may want to ask me, though I am conscious of giving evidence from my seat in respect of the shareholders. We're talking about the properties, there being 10 who are not milking platforms, so don't already come within the boundaries of the dairy exemption. There are 2 properties that Ms Harris has identified that could have made it through that exemption if timing of consents had been obtained. And then there's a further 3 properties that expanded an existing milking platform but did not put on a second shed and did not need a new effluent consent for that expansion. So I just wanted to clarify the exact affected properties we have there in the mix there, sir. And then next, just coming on to your questions of Ms Rushton regarding nitrogen reductions, Rangitata South's 3 main water take consents do require the scheme to administer its shareholders under a scheme management plan. That scheme management plan does include in its objectives management of nitrogen leaching, and the shareholders have been working on farm environment plans and audits with RSIL in compliance with that scheme management plan. That scheme management plan was also approved by ECAN at the outset and is reviewed annually. So management of nitrogen leaching has been underway, administered by RSIL. And so that's in part where a lot of the information has come from for Dr. Truig's analysis. There are also some shareholders in the affected group that do have their own farming land use consents, and so there is reporting to ECAN available there too. So the information is available. I'm conscious that there's a little bit of new information, but Ms Harris did allude to it in her evidence. Would the panel have any further questions in relation to those topics?
No, not for me. Nope.
Any questions?
No, not from me either. Thank you.
Thank you, Ms Keane.
Well, thank you, sir, and thank you, commissioners. That would conclude our presentation today, and I thank you all for your time.
Well, thank you for coming and managing the presentation in your professional way. Thank you.
Thank you, sir.
So now, Ms Fernando, the remaining business for the day is Dr Saunders' evidence, is it?
Yes.
On behalf of Barhill. And is that this morning or this afternoon?
No, that's this afternoon.
And the same for Selwyn District?
Yes, that's correct.
So that's all we have until 2 o'clock then, is that right?
Yes.
Very well, thank you. Well, we'll adjourn till 2 o'clock accordingly.